Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. All right, we're here this week with Emmett Macfarlane, who's a professor at University of Waterloo, and he's written some good stuff on the Sovereignty Act, which I'm going to link below. But Emmett, why don't we start with an explanation of what this Henry VIII clause means?
So Henry VIII clauses are legislative provisions that allow the executive to effectively directly amend legislation. And there's something distinctive about this. So a lot of laws delegate some type of legislative authority to the executive, usually in the form of regulations, and usually tied to the purpose of that specific piece of legislation. Henry VIII clauses are special in that instead of regulations or what we call secondary legislation, they allow the executive to basically take on the role of the legislature and actually rewrite primary legislation, the actual statutes on the books. They have in the Canadian context, these clauses have been upheld in the past. The biggest landmark case dates back to 1918, to give you a sense of where we were in terms of the democratic principles underlying this. And this involved a War Measures Act. World War I had not yet ended. It was a clear state of emergency tied to defeating the enemies in the war, and over time they have been upheld in other contexts, but usually tied to pretty serious, either if not emergencies, then things that we would imagine are akin to kind of peace, order, and good government. And indeed, the last big time that the Supreme Court dealt with a Henry VIII clause involved the carbon pricing, the federal carbon pricing reference. And so there's some debate as to how far these clauses can go. And in the
Okay.
context of the Sovereignty Act, I think this is by far the broadest we've ever seen, because the Sovereignty Act, as currently written, would allow the executive to rewrite literally any law on the books, and in a very nebulous response to federal initiatives that the Alberta legislature and Alberta government happened to decide they didn't like. And
And
so I
almost
think,
narrowly that the cabinet decides it doesn't like.
yeah, I think defenders of the bill would say, well, but you have to pass a resolution in the legislature first. And that's the one kind of tiny tie of accountability. And then after that, yeah, the cabinet has free hand to do whatever it wants, almost, as long as it's doing it in the name of defending provincial interests against federal initiatives, which is, again, is very nebulous. And so I don't think we've ever seen a Henry VIII clause so broadly worded and so amorphous. So I think it actually butts up right up against the limitations that the court has articulated in the past about what can be done with these things. It's really an attempt to usurp the role of the legislature entirely. I think it would, and indeed should, be found unconstitutional just on that basis alone.
But there are other ways in which this bill is unconstitutional. So why don't we talk about some of those other ways that you've identified?
Yeah, and so we can speak of unconstitutionality in both a specific legal sense and in a broader constitutional sense. But in the specific legal sense, the bill does a number of other worrying things. One is with its fundamental purpose. Its underlying objective here is not merely the protection of provincial jurisdiction. In fact, the entire scheme is directed at federal sovereignty, federal jurisdiction under its division of powers.
Mhm.
The preambles to the bill make this clear, but the fact that the bill is expressly set up to allow, among other things, the executive to direct provincial entities, which include everything from municipalities and universities to the police, to violate federal law. And in fact, that the exemption in Section 2B of this bill actually specifically permits provincial entities to violate federal law should worry anyone. It's not an attack on a specific federal head of power. It's not an attack on a specific policy. And this is where you see some right-leaning lawyers who have defended the bill kind of say, well, it actually doesn't specify any unconstitutional law, regulation, or activity by the executive. But I think my response would be the whole thing is a gateway to unconstitutional activity. And in fact, that's the underlying purpose of the bill. And you don't include an exemption to allow provincial entities to violate federal law, and not have that read as part of the purpose of the bill. So that's one way I think the law is plainly unconstitutional. It's not just an attack on a specific federal power. It's actually an attack on the idea of federalism. And I don't mean this in a wishy-washy, like they're being rude to the unwritten principle of federalism. I think they're actually attacking the structure of federalism. They're attacking the division of powers. Another way the law is actually legally unconstitutional is it is also a usurpation of the role of the courts.
Right.
It actually, the way it is set up, is not merely to allow the legislature or the government to proclaim that they think a federal initiative is unconstitutional, that a federal law is violating provincial authority. It's actually set up to transform such a declaration into executive action that purports to adopt a view that the government can take action to deal with a federal law that it deems unconstitutional, or that it deems just harmful to Alberta's interests. And so, in fact, the plain text of the law actually, even if the federal law is valid, the province can apparently do what it can to negate it. But in the context of unconstitutionality, of course, we know that the role of courts are to define unconstitutionality. And I'm actually sympathetic to some constitutional theories that give legislatures a role in constitutional interpretation, in pushing back against court decisions. But what the legislature or an executive cannot do is purport to govern the jurisdiction of the other order of government. And that is clearly within the role of the court. So I think this bill as written also violates Section 96 of the 1867 Act in terms of it's a violation of the jurisdiction of the superior and appellate courts, the federal courts of this country. Now, the law is also more broadly unconstitutional, and by that I mean it actually violates most of the basic unwritten principles and norms of our system. It's a violation of the separation of powers, because it sidelines the legislature. It's a violation of responsible government because it basically would allow the executive to legislate without being held to account by the legislature. So it's really a fundamentally anti-democratic bill that goes to the heart of the parliamentary system. And I think it serves in a way to actually, it's basically almost a secessionist bill. It kind of tries to remove Alberta from the ambit of a federal state and pretend that Alberta has ultimate sovereignty, and not a shared or divided sovereignty in the context of our federal system. So it's unconstitutional in all manner of ways. And as I've written, I still think that it's the most unconstitutional bill in modern Canadian history.
Yeah. I guess one of the things that kind of gets me is every time these objections get raised, someone like Danielle Smith says, oh, we're just doing what Quebec does. But this isn't what Quebec does. And I'm wondering if you can just kind of give us a little sense of what it is they think they're trying to accomplish, that Quebec has done, and why this is not that.
Yeah, I mean, and Quebec has certainly been capable of pushing constitutional boundaries. Bill 96 introduced a purported amendment to the Constitution of Canada that Quebec is not able to affect unilaterally. But Quebec has never actually passed legislation designed to attack the very basis of federalism. And you even see an attempt by the bill itself, but Danielle Smith and people around her to leverage the type of rhetoric you see in Quebec. So one of the preambular statements in the bill actually speak of Alberta's unique identity and shared culture. This is right out of the Quebec playbook, yeah. But Quebec actually at least has a claim to a particular identity and culture.
Speaking as someone who grew up in Alberta, making more money than everyone else is not a unique culture. But
right. I mean, it's even, I mean, I don't even know that it's possible to identify what they mean by their unique culture and shared identity, but it's, I think I am hard pressed to find that particularly compelling. And so we've never seen an attempt by Quebec to do the various things that this bill is purporting to do. And I mean, I could only repeat what I was just saying about its constitutionality, but to my knowledge, Quebec has never passed a bill that comes close to this. It really is audacious if it wasn't so dangerous.
I guess what are the avenues that other governments have around this bill? I mean, there's everyone's talking about dissolution, but I'm kind of starting to get this whole Mean Girls thing about it. Like, stop talking about dissolution because it's never going to happen.
Disallowance.
Sorry, that's what I mean. Yeah.
So, I mean, I think the problem is, as bad as this bill is, efforts by the federal government to employ something like disallowance, or efforts to pressure the lieutenant governor of Alberta to refuse assent or to reserve, these things would only cause their own constitutional crisis. The disallowance power is firmly, by convention, unavailable to the federal government, and I think it would take really an insurrectionist act upon by a province to really justify the lawful legal use of the disallowance power, and I think actually a lieutenant governor refusing assent is even a more severe and flagrant violation of the Constitution. The other thing it does, the B part of that, is that it would actually potentially help Danielle Smith by proving, and I say that in air quotes, proving that the federal government is this intrusive power interfering in Alberta's sovereignty. And so I think, that the next best option, depending on what form of this bill passes, because yesterday they were talking about amendments, and we don't know what those amendments will exactly look like yet. But the best course of action, if the federal government or another province really wanted to instigate some fast movement here, is to use the reference power, the federal government refer to the Supreme Court or another province to its Court of Appeal, a set of constitutional questions about this bill and get the opinion so that there's a relatively swift judicial decision that finds this unconstitutional and hopefully puts an end to it.
And if they were to do a reference, what would an injunction, or would they be able to do an injunction with that at the same time?
No, it wouldn't be. I mean, they could in a parallel process, seek ordinary litigation, although it'd be a little weird why you would do that and have a reference. References are technically non-binding, so they couldn't take the form of an injunction. But in practice, both courts and governments have treated references just as if they were binding. So one would expect, in the event of a negative ruling against this bill, that Alberta would concede and it would be off the books if it were found unconstitutional.
Okay.
And then there's always the risk that they don't, and then we have a very real constitutional crisis, I think.
Yes, indeed. And it almost sounds like some of the people around Danielle Smith are actually hoping for that, but I guess we'll see. All right. Well, thank you so much for taking the time to do this and to explain this to us. And we'll do this again.
Thanks for having me.
All right. Thanks.
That's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.